Well, thank you all for joining us today. This Zoom meeting on the Paycheck Protection Loan and the Family Medical Leave Act. My name is Sue Nicholson. I'm President and CEO of the Monroe Chamber, and I'm pleased to join with Regions Bank and Allen Green and Williamson to sponsor this event, this Zoom meeting for all of you. It is my privilege to introduce our speakers and then to turn it over to them. So the first speaker is going to be Jerry L. Stovall, Jr., an attorney with Breazeale, Sachse, and Wilson LLP in Baton Rouge, and he is going to discuss the Families First Medical Leave Act, and he is by audio only. And then he will be followed by Chris Schibner, Senior Vice President, Head of Public Policy and Corporate Affairs at Regions Bank, and he is out of the Washington, D.C. office. He's going to give an overview on the Paycheck Protection Loan. He'll be followed by Kevin T. Smith. Kevin is the Senior Vice President and Market Executive for Regions Bank, and he'll discuss the application process and reporting requirements. Tim Green, CPA and partner with Allen Green and Williamson, will address some practical issues in compiling the application, and he'll also touch on the employee retention tax credit and its impact on business. Our question proxy is Ami Buchanan, who's CPA and partner here with Allen Green and Williamson. And if you have a question, if you'll just click on the box at the bottom of the page and type in your question, we will take those at the end of the program. And at this point, we will turn it over to Jerry Stovall to start his presentation. Jerry, the floor is yours.
All right, thank you. And somebody's got the PowerPoint to put up there. All right, y'all, you should see a PowerPoint fairly soon. I appreciate you meeting with us this afternoon. What I want to say real briefly before we get started is everything I'm going to say, not want at the risk of sounding too much like a lawyer, is best knowledge at this time. Everything is pretty much subject to change. You're probably aware we have received many updates, guidance, and supplements from federal government, particularly the Department of Labor and the IRS over the past 2 weeks. We now have the final rule from the DOL, which interprets the Families First Coronavirus Response Act. That's a mouthful, so I'm just going to call it the FFCRA or the Act as I go through this. We now have the Act, we have the final rules, which really flesh out the Act and tell us how it's going to be applied. Unfortunately, the Act and the rules conflict in some regards, and the rules are internally conflicting in some regards. Last evening, several senators and congressmen sent a scathing letter to the Department of Labor complaining about several specific aspects of the final rules that they thought did not comport with the intent of the Act itself. There's a few in particular I just want to make you aware of, and the reason I'm doing this is these are subject to change. The rules can come out and they can change them again, which, as you'll see from the things they're concerned about, would be massive changes for you as employers. One is, the rules pretty much say if your employer doesn't have work for you, you're not eligible under the Act. You can't get either emergency paid sick leave, the EPSLA, or Emergency Family Medical Leave Act, the EFMLA. You can't get either if your employer doesn't have work for you. If they've sent you home, they've laid you off, they've riffed you, they fired you, you're not entitled to that. Some of the congressmen don't believe that's the intent. They think employees ought to be able to participate and get paid leave even if there's no work available for them. Second big thing is intermittent leave is generally only available under the rule if both the employer and the employee agree. It's a rare circumstance that one can force the other. And they said that's not the intent. They believe that the intent was that the employee could take intermittent leave when the employee wanted to. And last, and this is a huge one, that healthcare provider, for those of y'all that are healthcare providers or you've kept up with this, healthcare provider, for the purposes of who can be exempted or excluded from the protections of the Act, is incredibly broadly defined. Almost anyone that touches anything to do with healthcare or patients or patient transportation can be excluded as being employed by a healthcare provider. And they argue that was not the intent at all, that it's supposed to be much more narrowly defined. If they change that, particularly that one, the third one, the healthcare provider, that's going to be a massive change. We have helped a number of healthcare providers, dozens over the past few days, provide their employees with exclusion letters saying you are not covered, you're not going to get the benefits of the Act. So I'm just telling you that to say, keep your eyes open. This is a moving target as we go. The first, if we can go back, is it back one slide? Can you go back one slide, I think? Employees notice obligation, there we go. The department, as I said, we have the DOL rules and we have the IRS guidance. They don't completely agree on this, so I'm going to tell you in the main how this looks. The employee must tell you something. Those of y'all that are familiar with the FMLA, and this is quasi-FMLA, if you will, are familiar. The employee must put you on notice that they need leave. At the very beginning, they don't have to say FMLA. They don't have to say FFCRA or EPSLA or EFMLA. They need to just convey sufficient information to you that would put you on notice that their reason might be covered by the Act. If it's for the purpose of a school closure or child care, they're supposed to, and this is the timing of it right now, this is the timing aspect, they're supposed to give you notice as soon as is practicable. That really shouldn't be an issue because we all know that pretty much all the schools in the state are closed. I've had some people call me and say, well, my child has been able to do their teleclass. They can do it online or remote, so their school isn't closed. And that's not what the Act and what the rules say. What the rules tell us is if the physical school is closed, the fact that your child can take classes online or they're doing remote education, they're still closed for purposes of the Act. So if LSU is doing all their classes remotely, but the physical class, the campus is closed, then it's closed. The LSU is not a good example because those kids are over 18 and they're not going to be covered as a general rule. If you take off, or if the employee takes off for any other reasons, let's say any of the other 5 reasons specified in the employee paid sick leave provision, the EPSLA, there's a little bit more loose standard for them. They have to notify you, put you on notice the first day after they take leave, which is a little bit unusual. Usually it's before leave, and the DOL differs a little bit with that, but the safest is to require your employees to tell you as soon as practicable, no later than the first work day after they take leave. That's going to be your trigger mechanism to start your process of what you're going to have to do to document this. And the DOL has not given us any specific documents, much like the FMLA. You have WH 380 and 384 and all the different forms you can use on the Department of Labor website for the FMLA. We don't have those yet. So what I'm strongly recommending is if you're a healthcare provider, do your own exclusion notice. Real simple, real easy. For those of you that aren't healthcare providers and are not going to exclude your people, you're under 500, I'm assuming that's why you're on this call, you should go ahead and put together your own FFCRA leave request. Very similar to the FMLA form, but track the language, and we'll go through what we need to have in there. Track it, because from the day you get notice, that's your trigger mechanism and your timing to start getting these forms. You can advance the slide. Oral notice is sufficient to start the process. The employee just needs to put you on notice of the leave. After that, the DOL says you can require documentation per your policies. We're not really sure what per your policies mean. I would suggest at this time, as you're going through creating your form, that you go ahead and revise your handbook, your policy for leave notice, and I would drop in a section on FFCRA leave and say specifically that employees must provide you sufficient verbal notice or oral notice, and then they must provide you in a timely fashion the written notification that you're going to require. Just in case you ever get in a fight over this, you'll be able to point back and say, my policies required it, because if they don't, the employee could have an out on that. The DOL and the IRS conflict a little bit on this. Under the IRS, you're absolutely going to need additional documentation. I would suggest, as I said, you create your own leave request. I would create a checklist. I live with human resource people on the State Council of Law SHRM and on the GBR SHRM board, and that's kind of my universe, and we're big fans of checklists. It keeps you from making mistakes, and it's easy to make sure you do everything. So I would do that for this process as well. I would be very hesitant to not allow someone leave because they didn't provide me documents in a timely fashion. I would really want to be able to prove I've been over backwards to do that. Will you advance the slide? Okay. As a general rule, the employee needs to tell you her name, dates for which she is requesting leave, the qualifying reason, and an oral written statement that they're unable to work. And keep in mind, that's the key. The trigger mechanism for all the paid leave under the FFCRA is that the employee is unable to work or telework because of these 6 things. If the employee is able to work or telework, then you never get into the reasons. They are not eligible for paid leave because they can work or telework. Right now, as I said, if you have sent them home and you don't have work for them, then they're not eligible for leave. And this gets a little odd. If you have work for your staff, let's say for 4 hours a day from home, and they're working from home for 4 hours a day, then their only potential leave entitlement is that 4 hours. It's not the 4 hours during that day if they usually work 8 that they don't have work. That's just unpaid leave. It's only the 4 hours that you did have that they could take leave for. And I know that gets a little circular. It's easy to talk yourself into a box on that if you think about it too much. I would suggest that you have your employees, as soon as you get the notice, you have them fill out your leave request. That's going to start your documentation. The DOL, some commentators said the DOL request, the DOL rules require this request before the employee can take leave. I would not do that. I wouldn't deny leave, certainly now, for these reasons until they gave me written request. I would not. I would let them take off. And absolutely for anything other than child care, if an employee came to you and said, my physician has indicated that I might be exposed, I might have the virus, I need to go home and self-quarantine, I would never tell them, no, you can't do that until you fill out this form and give me the request. Don't do that. Send them home. Will you advance the slide? I'm sorry, you were right. Hold on right there for a second. The DOL continually refers to the IRS for the tax credits. You're going to need to create and maintain these documents for a period of 4 years because the DOL is going to ask for them. As I said, the rules provide that you don't need to allow leave if the employee doesn't provide you with the required documentation. I'd be real careful in getting that strong and not doing it. Under the FMLA, the old FMLA, before the pandemic, you could really do that with much more liberal nature. Now, you'd be very hard-pressed to do that safely. Keep in mind, everything we're talking about in this realm, this arena, is geared for the employee to keep the employee safe at home. Under most circumstances, they could be exposed or be contagious, which is better for the country, better for the employee, and better for everybody. You don't want to be fighting against that general principle if you can avoid it. So be really careful with that. The written request you have the right to get, which you should do for the IRS purposes, is very similar to the oral, but it's got a little bit more in it. You're going to need the employee's name, the dates for which they're going to be leaving, having the paid leave, a statement that of the COVID-19 related reason that they're asking off, and it says, the rule says, and written support for that reason. We don't know specifically what that written support is. For example, reason number 3 to take emergency paid sick leave is going to be, if I'm not mistaken, the employee has symptoms of COVID-19 and is seeking a diagnosis. There's really not much documentation, supporting documentation to be had for that, other than maybe an email or a written statement from the employee saying pretty much that. I have a low-grade fever, a dry cough, and I've called my doctor to get a diagnosis. That's going to trigger item number three under the EPSLI, that's going to give them the ability to then get 80 hours of paid leave or 2 weeks of their average work, depending if they're full-time or not. If there's some other reasons, you might have some documentation you could get. You could ask for a school closure order, but you're really not going to need that in this circumstance because we know they're all closed. 4 is a big one that you see at the bottom there. That's a big change. A statement that the employee is unable to work, including by means of telework, for the reason. Again, create your own form, use it for every employee, and I would use it for every time that they need to take leave. As you know, the reason for the emergency paid sick leave is probably going to be different. It might be different than that from the emergency family medical leave. The family medical leave is only for child care. Emergency paid leave is for 5 other reasons, including child care. So you would want to get the written documentation for each one of those. Will you advance the slide? When you're looking at the documentation, the reason they're taking off is going to determine to a large extent what you get in that documentation. If it's for quarantine or self-isolation, name of governmental entity or healthcare professional that's recommending or issuing the order. In our case, I don't think you need to do that. Everybody has seen our governor's quarantine order, so I don't think you would need to do that. Keep in mind, an employee can't trigger this themselves. Self-quarantine without the advice I'm sorry, we're talking about number 2 now. If you've got the advice of a healthcare provider advising you to self-quarantine or self-isolate, an employee can't trigger that unless they actually get advice from a healthcare provider. I feel a number of incidents in the past couple of weeks where an employee has said, hey, I was exposed or I'm not feeling good. I think I'm going to self-quarantine for 2 weeks. Technically, that doesn't trigger the act. They need to say that I've received advice from a healthcare provider indicating that I should do so. Now, you might think as an employer, well, that's fine, that's no big deal. I'll just go ahead and be a little bit more generous and give them the leave without that advice from a healthcare provider, because I sure don't want them coming to here if they might have been exposed, and that kind of fits with the reasons for the act. That's great, except the IRS will not be happy if you take the quarterly tax credit and they come in and they look and if they audit you. And I'm not going to begin to opine how the IRS is going to go about doing that with all the companies that are taking advantage of this, but if they come in and look and you don't have proper documentation showing that the employee had symptoms and sought the diagnosis of a physician, you could lose the tax credit benefit for that and have to pay it back. Again, I have no idea how likely that is, but technically that's what the rules say. Keep in mind, you cannot get the tax credit. And I'm not talking about the PPP loan. I'm talking about the quarterly tax credit allowed under the FFCRA. You can't get that tax credit for money you paid before the act was effective, April 1st. You can't get money, you can't take that credit on money you pay to people that are not covered under the act, that you give leave to that's not triggered, nor can you take that credit for money you pay over and above what the act allows. Keep in mind, for EPSLA, it's a maximum of $510 a day, and for EFMLA, basically taking care of a kid at home, it's $200 a day, and they've got maximum caps on each. If your pay is richer than that, I believe you can get the tax credit up to the maximum, but that's it. You can't get it for more. So you want to make sure you've got the documentation. Even though you're willing to give the employee the time off and to pay them for it, if you want to get the tax credit, you need to have that document in your back pocket when you go about it. For school and child care closure, you need the name and age of the child, the school, and this is a big change as well, a representation that no other person will be providing child care during the period for which the employee is receiving the leave, and it says a suitable person actually. That was not in the rule in the act at all. That's added in the rules. It makes sense, but that's something you as the employer are going to have to apply as you reasonably see fit to do it. I would want a written representation from the employee. I don't know how hard you're going to look at it if you think the employee has an adult child that came home from college who is helping care for their much younger brother or sister. I don't know how hard you're going to push that. The representation is probably sufficient, but just be aware technically the employee needs to be the only suitable person at home caring for that child. And this is someone who is not able to go to school because of COVID-19, or their child care is unavailable due to COVID-19. They're under 18 years of age, or 18 and under, or they're otherwise disabled and have to be cared for. If it's a child that is 14 years or older, over 14 years of age, and it's during daylight hours, you're going to need your employee to explain what special circumstances or special needs require them to be there to care for that child. I guess what the DOL is figuring is if it's during the daylight and this child is 15, 16, 17, they really don't need mom or dad there to take care of them. The employee will need to provide you something in writing sustaining why or substantiating why they do need to be home to do that. As I mentioned previously already, schools are still closed even if they're doing remote education or online schooling. All right, would you advance the slide? You probably understand that the EPSLA, that 80 hours or 2 weeks average of paid leave for the 6 reasons, you pay that at the employee's regular rate of pay. The Act says we do that in the manner we calculate the regular rate of pay in the manner done under the Fair Labor Standards Act. The rules say use a 6-month look back weighted average. I don't know if that's really going to change much. To be honest, I have not spent the time to do the math, so I don't know in what circumstance that's going to be a big variance. If you're really concerned about it, I would do the actual math on an employee and opt for the higher and pay them more, particularly since you're going to get this back in the tax credit. That wouldn't cause me a whole lot of heartburn, but I just want to make you aware that that is there. If you'll advance the slide. Okay, when can a small employer deny child care? Y'all probably know if you have under 50, means 49 or fewer employees, and an authorized officer makes certain determinations that certain conditions exist. Basically, if that means allowing this person off is going to cause you substantial financial hardship or business hardship, you don't have to allow employees to take off for child care. And I'm not getting into specific reasons. It's in the rules. Just be aware that that is there. When you're making your determination as to whether or not you have 49 or fewer employees, you make that as a snapshot in time at the time that the leave is to be taken. So you look at what date is the leave to start on, and that's the time that you determine if you have 49 or fewer employees. You count full-time, part-time, temporary agency employees, any joint employees. If you have a joint employee with another employer, you count them. You do not count independent contractors. So go through and do that analysis. You make the determination, document your thought process of why you're not going to allow this, and you retain your records. Even if you choose to do this, you still must post notice. The same as a healthcare provider. If you're a healthcare provider that can exclude your employees, you still must post a notice as well. If you're 500 over, you don't have to, but if you're a healthcare provider, you still do. All righty, advance the slide. 30 days. 30 days is significant because, as you know, under the EPSLA, the emergency paid leave, you're entitled to the paid leave if you have one of the 6 reasons the first day you're employed, that first day you're covered. However, you're not entitled to the EFMLA, the child health care, until you've been employed for 30 days. Well, that's coming down to how do we decide that? That just means you've been on the payroll for 30 days immediately before the leave is to begin. Now, if an employee has been fired after March 1st, and then you rehire them before December 31st of this year, and they were on your payroll for 30 plus days of the 60 calendar days prior to the time they separated. I'm sorry, and I said fired. It's you fired them, they quit. Either way, they were separated. If they're on your payroll for 30 of the 30 plus days of the 60 calendar days prior to separation, then you count them, you count those days towards their 30 to be eligible under the EFMLA. Also, if you have someone that has been with you through a placement agency and you pull the trigger and actually hire them direct, you count the time that they were with a placement agency to see if they're covered under the EFMLA. As a general rule, if a person was employed by you for any part of a day, it's safest to count that as a day. So if they're an hourly employee and you had them on your payroll for 30 minutes on one day, then they're going to be employed that day. Okay, go to the next slide, if you will. I'm sorry, okay, healthcare provider. This is very significant to those of y'all that are healthcare providers. I mentioned it earlier. If you don't want your people to be covered, you can exclude them, but you have to affirmatively do it. I would strongly recommend you do it in writing, that you either physically give to them or that you email to them, and you can prove you do that. There's some dispute as to several aspects of this. One, is it all or nothing? And we don't think so. We think that means you can exclude certain classes of your employees and not others. For example, maybe you want to exclude from the protections of the Act your direct caregivers, but not your back office support. We think you can do that. We think you can probably exclude them from EPSLA leave and or EFMLA leave. That is, I might exclude my back office people from everything, but then I choose to let my direct caregivers get the 10 weeks of paid leave for child care, but not the emergency sick leave. We think you can do that because those are 2 separate acts under the FFCRA, and the rules reference them as or, either or, so you can probably do that. We do not think you can pick and choose amongst the 6 reasons spelled out in the EPSLA, that if they're taking emergency paid sick leave, they're either eligible or they are not, that you can't pick and choose whether it's a governmental order or they're suffering symptoms or they're caring for someone. And I know that's getting real detailed, but these questions are coming up. And keep in mind the overall principle. You want to do this to take care of the employee to the extent you can. The rules recommend that employers apply these judiciously, which means don't exclude them if possible. When you do exclude, do it in writing and prove you gave it to them, or it's going to be a problem later on down the road. And this might be the last thing we can get to. I don't want to go over my time. Can an employer, I'm sorry, you will advance the slide. Yeah. Can an employer compel an employee to use accrued paid leave? And I'll put PTO as a shorthand. That's just any form of paid leave that you provide to your employees not covered by, the leave is not required by the FFCRA. Under the emergency paid sick leave, that's that 80 hours, no. The rules are very clear and the act is clear. The employee has discretion to determine if they want to use their accrued paid leave first or not, if they want to hold it in reserve. You can't make them use it first. For the emergency family leave, you know, that there's a 12-week period. The first 2 weeks are unpaid, and then the last 10 are paid. If an employee is taking off under the EFMLA, they're going to get coverage for that, and you can't make them, as I just said, I'm sorry, the EPSLA, you can't make them take it off if they want to. But under the EFMLA, that first 2 unpaid weeks of the child care leave, you can make them use accrued paid leave if you choose to do so. So you can make them do it during that first 2 weeks. The rules are pretty clear. The remaining 10 weeks, the rules aren't clear. We don't have a high confidence level that you can or cannot make them use their paid leave. So y'all, I got through about half of the slides. I think you can get these. We're going to send them out, I believe, after our presentation today. I appreciate your time very much, and y'all hang on and listen to the other speakers.
Thank you, Jerry, and we'll be taking questions at the end of this, this Zoom meeting. Our next speaker is Chris Greiber, who will talk about the Paycheck Protection Loan. And Chris, the floor is yours.
Thank you. And, you know, really one of the points of similarity that I would say between the two presentations as we talk about what's happening as a result of federal legislation is that this is a moving target. Legislation is, you know, written in general language, and it's up to the agencies to implement. And, you know, the CARES Act and the part of the CARES Act that I'm talking about is really focused on relief and getting money out to business owners to pay employees. And so, you know, part of this is speed to try to get this out quickly. And in doing it in a kind of expedited manner, it means at times that we're figuring things out on the fly, and clearly the government is figuring out some of the rules and regulations around this, and banks are as well as in how they interact with the SBA in the Paycheck Protection Program. And Kevin will add some additional details about that process. But it is very fluid. I mean, this is intended as a $350 billion aid relief program. There's a lot of discussion now, and there was an effort and actually legislation introduced to add an additional $250 billion to this program. And I would say that it's likely that there will be more money added. Just the timing of that is probably uncertain, and whether that gets wrapped up into other legislation. Just for some context, at the end of the day yesterday, the SBA said that banks had received about 300,000 applications, totaling about $75 billion in loan requests. Regions itself has received tens of thousands of applications. I would emphasize that $75 billion number, a very small percentage, probably less than 1% of those loans have actually been funded. So the timing of the funding of applications and the speed, there's still a lot of variables in place. And you know, the average loans as Regions has seen them have shrunk over time in the application, meaning maybe larger businesses that are eligible, under 500 employees or less, were the most kind of ready to apply on day one. But to just give some context for the program, this is intended for small businesses, defined as smaller, 500 employees or less, although certain rules can apply, and I would tell you to consult the SBA website, but we can provide those specific links. There are some rules that allow companies that the SBA defines as a small business that are larger than 500 employees to apply for this loan. In addition, certain other SBA rules have been waived. For instance, for businesses in hotels and in the food service industries, because those companies are hit hardest, and also for franchisee rules to allow for multiple locations, in a sense, to apply for loans. There's also specific guidance around affiliation rules if there's joint ownership or private equity ownership, if that's relevant. And again, the best source and really everything that I say is coming of information, and everything that I say is coming from the treasury.gov website, which on the front of that website has a link to the small business lending program right at the top, and walks through some guidance, frequently asked questions, the application, standard application, for instance, and to give clarity. But the goal of this program is to provide loans to cover payroll costs and related costs, mortgage, interest, rent, utility costs for what is the average of 2.5 months of, or the average of 2.5 months of the average payroll cost. Again, including those other elements, although given the fact that SBA expected a lot of interest in this program and a lot of take-up, which we've seen so far, that 75% of those costs have to go directly towards payroll. So only 25 can go to the other categories. Payroll costs are capped at $100,000 per employee, for instance, so that's a key. These loans are 100% guaranteed, and they can be forgiven subject to certain conditions, and I'll highlight kind of the broad categories there. These loans don't require collateral, and when the term after 6 months, there is a one in the repayment period, there is a 1% interest that will be, begin after, or will nothing will be billed in a sense till after that 6 month deferral. April 3rd, Friday, was the start of the program. Many banks started taking applications, large and small banks, some even large and small banks delayed until this week so that they had a little more clarity. But that began on April 3rd, and I mentioned the volume and the fact that there's an anticipation that there will be, in a sense, a second tranche of loans. Independent contractors, self-employed individuals, though, cannot apply through this program until this coming Friday, April 10th. So there was a split in the application process there. The Paycheck Protection Program, the loan has a standard application that is available on the Treasury website, and that does require businesses to attach a required documentation, and Kevin may provide a little more detail there. But the application, again, is standardized. Every bank is taking the same application, although ultimately the loan document might look a little different for each institution. So, that documentation is primarily payroll documentation. The program is open to June 30th, subject to it having funds. And again, I think from Congress's attention to this, that the funding will meet the demand. It's just may be a matter of timing. Again, just to highlight a little more detail, the loans can be used for payroll costs, including benefits, interest on mortgage obligations, rent, utilities, for instance. Again, the capping salaries at $100,000 is a key element. Employee benefits can include costs for vacation, leave programs, medical or sick leave, state and local taxes, assessed on compensation, for instance. It is worth noting that the PPP covers sick leave, but not in the case where the tax credit for qualified sick and family leave wages are allowed. So that's a distinction to keep in mind. The loan itself is 100% forgivable, and the money will be forgiven essentially if after 8 weeks of getting the loan that the employee numbers and payroll are held steady, and there are specific details about what percentage will not be forgiven if that is not the case. And that one of the reasons, and Kevin will get into more detail, why the banks, who are the intermediaries in this, but lending the money off our own balance sheets, will make sure that this information is accurate, is because that is the basis for how the forgiveness occurs. It's the government who is guaranteeing and forgiving the loan, and again, the banks are the intermediaries. As a general rule, the way the program was developed, it's developed to run through the SBA's kind of electronic portal to speed up the application process, although it's clear that that portal is being overwhelmed by volume, but to allow, again, for speed in the process. One of the concerns of banks when the program was first rolled out and the first rules were developed was who is responsible for the information that is provided by the applicant, and what is the responsibility of the bank. And one of the clarifications to speed up the process is that if it's an existing bank customer, then Bank Secrecy Act, any money laundering rules are effectively waived because we already know our customer, and therefore we don't have to do the due diligence we would be required to do around non-customers to speed up our process to get the loan to the SBA for approval and authorization. That means, essentially that borrowers should go to the bank where they have the relationship, because that process will be much smoother for them there. And that's really designed to speed applicants through the process, because those rules are not waived for non-customers. So again, from the perspective of what, those are the major elements of the program. The borrower under the rules is the one who is certifying that these are accurate documents. The bank does need to make sure we've received them and they say what they say. The applicant says they say, but it's the attestation of the borrower that is the source of the guarantee, and it's the borrower who's responsible for that information. And that's clearly laid out. And again, that's partially to speed through the process and get it to the SBA. At that point, the bank is taking in applications. We have some verification, as I noted, and then we have an interface with SBA for approval. And really, as we get into the details of kind of how that process occurs at Regions Bank, and other banks would be somewhat similar, I'm gonna turn this over to Kevin to highlight those elements of the PPP.
Okay, Chris, thank you. Thank you, Sue, for organizing this. As Chris mentioned, many of you have probably already been to the site, but if you'll go to sba.gov, there's a copy you'll see a link to the Paycheck Protection Program, and you can click on it and you can actually retrieve the application. And I think it's probably pretty fair to say that for a government form, it's one of the simpler applications that I've seen. It's clearly the government's trying to make it easy for businesses to complete the form and to apply for much needed loan funds. The application is 2 pages. It's actually 4 pages, but there are 2 pages that you actually, as a applicant, will complete, and then there are a couple of pages of instructions. But again, the form is pretty easy to complete. I'll just maybe kind of hit on a couple of items on the application that you might want to look at when you pull it up if you've not already. One item it's going to ask you to input into the application is your average monthly payroll, and we'll talk a little bit more about that in just a second. And then it's also going to ask you the number of employees that your business has, and that's not full-time equivalent employees, that's total employees. So part-time, full-time, all employees would be included, and again, that number needs to be below 500 unless you are in a business that the SBA approves as a small business that might have more than 500. And then Chris mentioned about certain restaurants or certain businesses in hospitality and restaurant space that requirement is by location versus total employees. There's a place for the business to list ownership, and there are just a couple of short sections, 8 questions that you give yes or no answers to. That'll be pretty easy to get through. And then on the second page, there's a certification section. I just want to highlight just a couple of lines on the certification page. So first of all, as an applicant, you need to, you'll be certifying that you were in operation on or before February 15 of this year. You'll also need to make a statement that current economic uncertainty make the loan necessary to support your ongoing operations. Also, you'll make a certification that the funds will be used to retain workers and to maintain payroll or make certain other payments that are spelled out: mortgage payments, lease payments, utility payments. Those are all eligible uses for the funds. The applicant will also provide the lender documentation verifying the number of full-time equivalent employees on the back end when you get to the loan forgiveness part of this. Those are pretty. There are a few other certifications, but those are the main ones. And again, that you can go to sba.gov and you can print a copy of that application. And regardless of which bank you use, they're going to be using this approved application. In terms of what you need to bring to your bank, and I will say that this will vary slightly from bank to bank. I've just talked to a few banking friends in Monroe, and I've also looked up on some websites of some different banks just to see what they're asking of their clients to bring to them when they complete the application. So recognize that, but I think some of the items I'm going to mention are going to be pretty consistent from bank to bank, with again just some slight variation. One thing you'll need to prepare is your 2019 or provide is your 2019 payroll cost, and also your year-to-date payroll costs through February 15 of 2020. I've seen this in the form of just if you use QuickBooks, there's a choice where you can print your payroll for the defined period. I think in most cases that will suffice. If you use a payroll processor, they might also be able to provide you that payroll cost for the 2019 year and from January 1 of 2020 through February 15. You'll also, as I mentioned earlier, you'll need to be able to provide the number of employees as of December 31st, 2019. You'll also need to provide the number of employees as of February 15, 2020. You'll need to know your industry classification code or your NAICS code, and that can be found on your tax return. You'll also be asked to provide your IRS Form 940 and your IRS Form 941, which is your quarterly federal tax return. And then you'll probably be asked for a W-2 summary, or I think a W-3 transmittal. Those terms are used kind of interchangeably, but one of those documents. And let's see, also any employees that earn more than $100,000 in compensation. And compensation, for the purpose of this particular requirement, is salaries, wages, commissions, tips. Doesn't include retirement contributions. Doesn't include the portion of health benefits that you might pay on behalf of the employee, but just their salaries, wages, and again, commissions, tips. You'll also need to provide a breakdown of payroll benefits for the 2019 year and through February 2020. I've mentioned group health care benefits that you might pay on behalf of your employee, retirement benefits that you fund to their maybe 401k. If severance has come into play for any employees, you would provide that. And then vacation pay, if it's not already included in the wage that you provided, you would include it. So that pretty well addresses the reporting requirements that you can expect. Again, it might vary a little bit from bank to bank, but it should be pretty close. I'm going to, I sent this to Sue prior to our call. I don't want to get into a lot of detail on our call today because we're limited with time, but it's an Excel spreadsheet that helps you determine your loan amount on the front end, and then also your loan forgiveness amount after your 8-week period ends when your loan is originated. So I'm going to hit on just a couple things, and also ask Sue to maybe forward this form out to participants on today's call. So in looking at your or in deriving your loan amount, the first part of that is your payroll costs. And so again, salaries, wages, commissions, vacation, sick pay, exclude any pay above $100,000 for a particular employee. And this is gross wages. So not after you subtract out any federal taxes that might be due on the employee's wages. You don't get to add back the employer portion of payroll taxes. This is gross wages. Also, your group health insurance costs, your retirement benefit costs, any state, local taxes, that goes into your payroll number. So if you look at that number for the 2019 year, you divide that number by 12, and that gives you the basis to then multiply by the 2.5 factor to get to your maximum loan amount. And so I'm looking at an example now where a borrower's payroll cost was $1.5 million for 2019. On an average basis, it was on an average monthly basis, it was $125,000. And then there were some other expenses for health insurance, retirement costs, and so this particular company's total payroll and related costs came up to about $153,000. When you multiply it times a factor of 2.5, they're eligible for a loan amount of a little over $380,000. That money, that $380,000, can be used for the following purposes, and Chris touched on it earlier, but it can be used for payroll costs, for health benefits, interest on mortgages, rent, utilities, and actually, and also interest on any other debt obligations that were incurred prior to February 15, 2020. The second part of the spreadsheet is it helps you calculate what your loan forgiveness might be. Hopefully, when you do this, when you get to the end of the 8-week period after you apply for the loan, hopefully 100% of it will be forgiven. But there is a possibility that if you spend a little more on non-payroll costs that you're allowed to use in the loan, that you might have to pay a part of that back. This spreadsheet kind of walks you through that. The couple of items that can cause a reduction in the amount of your loan have to do, as Chris mentioned earlier, with the number of employees you had going into this crisis, and the number you have as you complete your 8-week period. So, for example, I'm looking at this particular company. They went into they had a 32 full-time equivalent employees for the 8 weeks after their loan was approved. So 32 full-time equivalent employees for the 8 weeks after their loan was approved. They compare that back to their number of full-time equivalent employees for the February 15, 2019 year through June 30, 2019. And in this particular company's case, their employee count was 38, versus 32 that they had during their covered loan period. So they had about 16% less employee count. So they had to reduce their loan forgiveness amount by that 16%. Also, there's another component to that. If you reduce an employee's compensation by more than 25%, you have to take a reduction in your loan forgiveness for that. Now, if you have an employee that makes over $100,000 a year and you reduce his compensation, then you wouldn't count him. But for employees that make less than $100,000 a year, if you reduce their compensation by more than 25%, you'll have to take a reduction in your loan forgiveness on that. So again, hopefully you solve for your loan forgiven and you get all of it forgiven. But the good news is if you do have a residual loan after the forgiveness amount, the interest rate is 1%. You don't pay any interest on that until 2021, and that loan is good for 2 years at the 1% rate, and you can prepay that at any time. Let's see. And really, that's, again, I'll have Sue, or I've asked Sue already to send this out to the participants. I think this worksheet will help you. And I'll just conclude by echoing something Chris said earlier. I would advise you to go to your bank first on this. Your bank knows you, they know your business. This will greatly streamline the process for you. And I'd say after you complete the application, be patient with your bank. They're processing a lot of applications. I called a couple of my friends over the weekend. I drove by their office on my way to the office on Saturday, and their parking lots were full. They were processing PPP loans all weekend. I listened to my church service online Sunday and then came to the office after, and their parking lots were still full. So I know that bankers are working overtime trying to help their clients navigate through this very difficult time. And Sue, that's all I had prepared. I'll turn it over to Tim now.
All right. Today I'm going to talk a little bit, continuing the conversation as far as the Paycheck Protection Plan, and maybe give you a few experiences our firm has had in that regards, and maybe that would help you in your preparation of your application and so forth. We're a couple, and I was going to talk about the Paycheck Protection Plan, also about the emergency EIDL grants, and also the employer retention credits, which is kind of an alternative to the Paycheck Protection Program. So we'll be sending out slides after this presentation, and it'll have a little bit more detail in that regards. But kind of going to, I think the first thing I would do as far as is make sure if you're planning on filing an application, make sure that you're an eligible borrower. As they mentioned previously, you got to have a business would need less than 500 employees. You need to kind of look closely, I guess, at the 501c3s as far as nonprofits, independent contractors, self-employed are all eligible for it. Like governments are not eligible for the loan. So just make sure that you're covered by that. Kind of flipping to the third slide, you'll kind of flip ahead. Talking about the covered period, the Act says that you should consider for your base period in determining how much your loan is, says the 12 months prior to the loan. So you could say, I need to accumulate the information for the base period all the way up to the date of the loan. However, I think as a practical matter, the banks have most of them have kind of settled on the 2019 year as to the period to use for your base period and the term of your loan. But before I went and prepared all your information on that calendar year basis, I would touch base with your specific bank that you're going to be using to submit your application and make sure that's good with them. I know we've had with the ones we have prepared, I know the clients have kind of been switching back and forth between the year ended February the 29th, if they kind of had their 2020, if they had their payroll reports prepared for the first quarter of 2020, they were actually coming up through March 31st. But again, I think we've dealt with several banks, and the majority of them, I think, are using the December 31st year end for that base period. Okay. Flipping to the two different criteria, the main thing, I guess, point I would make here, Kevin and Mr. Chris have kind of covered some of the rules on that, is that your preparation of your application is dealing strictly with the loan amounts, which gets into the payroll cost, gets into the group health insurance, gets into the retirement amount, gets into the Louisiana unemployment and your federal unemployment. But I have people who says, okay, I need to get the utilities and the rents and et cetera. You do, that's on the forgiveness part. That's going to be in 2 months or 3 months that you're going to be working with your bank and deciding how much you'll be able to be forgiven. At that time, we'll have to be providing additional documents such as payroll reports, W-2, or well, I guess we wouldn't be doing W-2s at that point, but we would be having to provide probably payroll registers and that type of information to kind of document how much you did spend during this 8-week period from the date of your loan to the 8 weeks or up and so forth. So as far as utilities and rents and interest on mortgage, you don't need that now. You just need to be concentrating on the payroll cost and healthcare and retirement cost, and then your Louisiana unemployment and federal unemployment. Utilities and so forth do not have anything to do with your loan application at this point. At the end, when the forgiveness comes about, sort of on the back end, yes, that'll be important and so forth. Self-employed it's in the interim guidance that was issued last Thursday night. The thing with the independent contractors was kind of clearly stated in the law. It was a little bit confusing in the law itself, but in the interim guidance, it was clearly stated that self-employeds would be preparing their own applications and so forth, that the business that are paying the independent contractors, you could have read the law where you would say, okay, I'm going to pick that up as well and be able to increase my loan amount. The interim guidance, again, kind of cleared that up. I had down here that 20% on this slide, 20% of the base amount. The true way of doing it is to go through and take your average payroll per month and multiply that times 2.5 months. That's what your loan amount can be based upon. If you go through, just kind of as a practical matter, when we're looking at the numbers, we're going to increase the base by $100,000. Instead of going through and divide it by 12, multiplying times 2.5, the mathematical percentage of that is 20.83%. So we're just kind of rounding off for internal purposes. When you get ready to calculate it, you would do it by the specific divided by 12 and multiply it times 2.5. But we've used it kind of so much in my firm here that I was putting that down without thinking. But anyway, just divide it by 12, multiply it times 2.5. Okay. The forgiveness, that's going to be down the road. That's going to be 8 weeks after the date of your loan. You're going to have time to accumulate your records and so forth for that. So I would probably say in 75 days or so, in June sometimes would be probably when you would be looking at that and providing the additional information to your lender and so forth. Kind of on the next slide, the bank documentation. This is just some of the items that we're finding is very common between all the banks. W-2, and most of this has already been talked about. W-2s, W-3s, 941 reports. Another reason that the calendar year has probably become more popular is that you can take and reconcile your 941s, your W-2s with those numbers. If you're kind of falling within the middle of the quarter, then that's a lot more complicated and so forth. But the bar certification, as Mr. Kevin mentioned, your group insurance invoices, the retirement expense documentation. If you have another person preparing your application on your behalf, there is an agent service agreement that would need to be completed. Most banks kind of have their own application, so you need to be sure and get the one that's applicable to them. The completed SB application, as they've talked about, entities organizational papers, you'll need that to be provided. It may be with your bank, if you've been dealing with them for some time, they may have the organizational papers, but if not, you need to be sure to include that in the application. Okay. If you're uncertain about an item to conclude in wage space, I would include it. That's been my recommendation to clients. However, I would specifically spell that out on your application or on your attachments to your application that we're including this amount. Like originally, there was a lot of uncertainty about the independent contractors. In some of the applications that we're receiving, it says include the independent contractors. I think since the interim guidance came out, I think that really is just going to apply to independent contractors and self-employed. For the business itself, you would not include that. If you're kind of like a business paying employees and you're paying independent contractors, you wouldn't want to provide the independent contractors documentation and so forth, because that's probably only going to be eligible to be taken by the sole proprietor or the independent contractor. But again, if you've got things that you have a question about whether it's includable, we kind of make up a schedule saying, here's all the items, the payroll, the FUTA, the group insurance, the health or the retirement amounts. We take and list those. We provide the documentation to support all those. There's kind of a question about the K1s, partnerships and the income and so forth that's there. That's not consistent between all banks. There is quite a few that says that's not includable, but that's kind of similar to a corporation that typically pays salaries to the high income people. Typically that's the owners. That salary of that owner gets included in the computation for a corporation. You have that on one end of the spectrum. On the other end of the spectrum, you have self-employed and independents that are able to claim that income from those businesses and treat that as payroll for purposes of calculating your loan. So we kind of think to some extent that the K1s is kind of the same thing. However, that's probably a lot of people will not be in agreement with that. And there's quite a few banks that are not in agreement with that. However, I know that there's at least one or two that do treat that as part of the calculation. So anyway, the first thing I would do is kind of touch base with the bank that you're dealing with specifically if you're wanting to try and attempt to do that. So, which is one of the comments I'll make later on in the slides. To some extent, what I think is available and could be claimed in that payroll basis, to some extent, is not irrelevant. It's really the bank is the one that's the judge on it and decides what can be included and cannot be included. So I would touch base with your bank if you have any items that you're questionable about. Touch base with them for them to tell you how they view that and what their decision would be on that. Okay. Probably kind of running out of time here. Let me just skip over. Why don't I just skip over some of this? We'll send it out in the slides and you can just kind of read through it. Might just skip to slide number 10, which is about the emergency EIDL grants. This kind of lists what the eligible entities are to participate on it. It kind of shows the period that's covered there, which is January through December of 2020. The big thing that most people are applying for is this maximum advance payment. If you make a loan request through this program, you can request to have an advance payment made of $10,000. This $10,000 is not, you're not required to pay it back. And according to the law, they're supposed to pay that. The SBA is supposed to pay that within 3 days of your application. The application probably takes you 10 minutes to fill it out. And I think almost everybody is eligible to apply for that if you have a business and so forth, but you wouldn't want to check the definition specifically and make sure that is the case. But and we've had it for different entities or all the entities for a particular, say, a particular owner may have multiple entities, and he's filing this request for the advance on all of those. Okay. If you are an applicant, you shall not be required to repay any amounts of advance provided under this subsection. However, you do, as far as the loan forgiveness over on the Payroll Protection Plan, that $10,000 would be, which you cannot have it forgiven, the $10,000 over there. So, but as far as in this EIDL program, you're not required to pay that back. So it's basically a grant in that particular case. Okay, I'll cover just one other thing and then we'll get to questions and answers. The next to the last slide is the employee retention credit. It's kind of a good alternative, I guess, to the payroll protection plan. If you don't qualify for that, or if your loan amount is insignificant over there, you should at least look at this and kind of consider it. Again, it's an alternative to the payroll protection program. Businesses can't do both the payroll protection plan and this employee retention credit. Up to 50% of qualified wages, or you're eligible for credit. The credit is 50% of qualified wages. There is a limitation on the number of dollars per employee. It's $10,000 per employee, and you can receive a credit of 50% of that. You take and you're reimbursed for that through your quarterly deposits on your payroll taxes that you submit to the IRS. You reduce those until you kind of, I guess, got back the credit or received the value of the credit that you're entitled to. There is some provisions that you can take and request that to be paid to you and so forth, but the quickest way to get the refund is just to reduce your upcoming payroll tax deposits for the IRS. Last page is just contact information. If you have any questions, feel free to call me or email me on that.
Hey, Tim, this is Kevin. Let me interject one thing. And back on, you commented on the economic injury loan program, and you commented on the emergency grant piece of that. I want to make everybody aware that there actually is an economic injury disaster loan that can be up to $2 million, and that's at a very favorable interest rate. It's a 3.75% for businesses and 2.75% for qualifying not-for-profits, and the term of that can be up to 30 years. Also, the payments are deferred for 1 year, and that can be used for working capital, for other business purposes. And so, what I'm seeing with some of our clients is they're applying for a loan under the Paycheck Protection Program, but typically that loan is going to be less than $10 million. So they've got room to actually also access funds under this economic injury disaster loan program. So that can be found on the SBA website as well, sba.gov. So that's just something to make our participants aware of.
Okay, a good point to make on that. Great.
Well, thank you all for those wonderful comments and insights. I'm going to turn it over to Amy Buchanan to ask some of the questions that were sent in.
Hi, everyone. We had several questions on the Paycheck Protection Program. We did have one for Jerry on the Families First Act. What if you never get documentation from a doctor for the employee? Then how do you receive credit if you can't provide the documentation?
As long as the employee certifies to you, because I'm trying to think which one would be the doctor. If it would be the doctor recommended that they stay home, you'll need to get the name of the physician. Let me see, think real quickly. You'll get the name of the doctor recommending they stay home, the period of time, the reason they're recommending it. You're probably okay. If you get the employee to represent to you that information, even if the doctor never gives it to you, I think you're okay. If I'm not mistaken, the rules say that for those reasons you can rely upon and use the healthcare provider certificate under the old FMLA, if I can call it that, which is still in effect. You can still use that. If you don't get it under the FMLA, you can deny the leave. Here, I would not recommend that you deny the leave, just because if you look at the context of the act and what's going on right now, everybody understands that healthcare workers are grossly overworked. It could take a long, long time, if ever, to get some kind of a physical form back from them. And I don't think that's the intent of the act, or that a judge or jury, if push comes to shove, would look kindly on that. Because if you play it through logically, if they don't return it in time, your option would be to deny the leave and say it's not protected leave and terminate it if they take off anyway, or make them take off without pay. And I don't think either one of those is going to make you look good at all from a legal standpoint or from a public optics standpoint.
Okay, thank you. The rest of our questions have to do with the Paycheck Protection Plan, our program. So Chris or Kevin, I'll let either one of you jump in to answer these. The first question is, what about businesses who are shut down due to governor's order? Are they ineligible because they aren't working?
No, they would be eligible, and that's really one of the primary focuses of the program to help compensate businesses that are affected by the COVID-19. Chris, you might add to that. I'm pretty sure that's right.
That's correct. Yeah.
Okay. All right, but I think on that, they're going to have a little tough time at the end if they're not, if they're closed and don't have any payroll. When you come back and sort of figuring the loan forgiveness amount, that's going to be a little bit tough there, that they're going to have a challenge with that. This employer payroll credit business I was just talking about is a good alternative and may be ideal for that type of situation, where they can get the credit. I guess if they're closed down, that's also going to be tough to get that as well, since they would not sort of be paying it, or if they're paying a lot less, it may be. So I would probably check both of those. If you're
I was kind of assuming that they were closed temporarily, but the plan would be to reopen. Yeah, I agree. If they have ceased operations and don't reopen, then they wouldn't qualify.
And the other thing, just generally, I would add, and this may be broader than this question, but the program does allow for restore the number of employees and salary levels by June 30th for any changes made between February 15th and April 26th. So it does account for some changes in that interim period.
Chris, we did have a little bit of static when you were talking, when you were saying that point, and I did have a question directly related to that. So I'll just ask that question and maybe you can repeat what you just said. One of the questions was that we laid the majority of our employees off as of March 18th. In order to qualify, is there a deadline that we have to hire everyone back by? And I think that's what you were just alluding to.
Yeah, what I mentioned was that for depending on the application, if there are changes made between February 15th and April 26th and the number of employees or salary levels, those can be restored by June 30th and to not be subject to rules around or to the ability to forgive portions of the loan.
Great, thank you.
And just one other thing, because I am unfortunately going to have to drop off. Kevin's not here in a moment, but I do emphasize, and we've emphasized going to the websites occasionally, because some of these aspects change on a day-to-day basis, and it's worth looking at the FAQs, the frequently asked questions, on a particular day. There was only a slight change today versus yesterday around bank rules, but it's and loans that banks do, but it's worth checking. Sorry that I have to drop off at this moment, but you're in Kevin's capable hands.
Chris, thank you so much for participating.
Absolutely.
Yeah, Chris brought up a good point on the, if you'll go to the SBA.gov website, there is a link to frequently asked questions on the Paycheck Protection Program, and it gets added to every day. I didn't print the one for today, but I'd printed the one for yesterday. That would be that's going to answer probably a lot of questions that people might have.
Okay. Couple more questions. This one's, I guess, twofold, that was emailed in. As an owner and sole employee of my small business, is there any special steps I should take? And also his LLC was opened in November. So he wants to know also, does he qualify for the program?
If he was open prior to February 15 of 2020, he would qualify. In terms of him being a sole proprietor, they are eligible to apply beginning this Friday, April 10th. So sole proprietors, independent contractors, they would all be eligible to participate. And again, that they can start filing an application April 10th. Tim, I'll ask you agree with that?
Correct. And I think they're using for their base, they're using like, I think it's like 45 days or something. It's in 2020 that you're using the base, since you don't have a full year and so forth. That it's, I think it seemed like maybe January 15th to February 29th. I'd have to look up the dates, but that would be the base period that you'd be using to determine your loan amount.
Okay.
Yes, I think that's right.
Okay. Couple more. One is, when figuring the total employee wages, compensation, etc., do we tie this to total wages per the 940 or something else like Medicare wages per the W-3?
I'm going to let Tim answer that so I don't mess it up.
I think I'd tie it to the Medicare wages. If you look at like the W-2s or the 940, maybe would be the same amounts and so forth. But if you look at your W-2s, you'll notice box 2 a lot of times is different than your Social Security box. And your Social Security boxes even can be sometimes less than the actual wages that you draw. There may be something that gets, I think, group health, qualified group health and so forth gets deducted from your Medicare wages, I think it is. So the true wages is probably higher than what's on the boxes as far as the W-2, but I would probably just tie it into the 940 and kind of roll with that, because I think the banks are going to be looking at it and trying to tie in with either the 941 or the 940. So I would use the numbers that kind of match up with those numbers.
Okay. And our last question, Kevin, I think you did speak to this in your presentation, but have they decided upon an interest rate? I have noticed the information has changed a couple of times.
And yeah, you're right. It has changed. The interest rate started out at 4%, and then it on any loan that remained after the forgiveness, and then it got reduced to a 0.5%, and then it's finally ended up at 1%. And the loan, any loan that is not forgiven, is a 2-year loan with a 1% interest rate, and the interest is deferred for 6 months.
Okay, thank you. That's all the questions that we had.
Well, again, on behalf of the Monroe Chamber, Regions Bank, and Allen Green and Williamson, thank you all for participating. A special thanks to Jerry and Kevin and Tim and Ami, and then the person you can't see, Kim Smith, who is all of our technology and really been hustling to get that done. Thank you for participating again, and we will have the 2 PowerPoints, the Excel sheet, and this recording on the website later this afternoon. Thank you.